Welcome to SENDiass4BCP's webinar on mediation. Today we will be discussing what is mediation, what can you mediate about, when can you mediate, some things to consider, considering mediation, the mediation process, and where to access some additional support should you need it. What is mediation? Mediation is a more informal way of solving a dispute between yourself and the local authority, also sometimes including the Integrated Care Board, who are the health authority. It is a free service to you whereby a mediator, an independent and impartial party, facilitates a confidential meeting with the aim of reaching an agreement on the points of dispute, potentially preventing the need to apply to the first-tier tribunal. What can you mediate about? You can mediate about a refusal to carry out an EHC needs assessment or a reassessment of needs, a refusal to issue an EHC plan, the contents of an EHC plan, be it the needs or provisions, sections B and F of the EHC plan, the health or social care needs and provision, sections C, D, G and H. Although you're able to mediate on this issue, it's worth mentioning that these sections alone cannot be appealed. However, if appealing any other decision, you can request that the tribunal make recommendations on these sections in addition. You can mediate on the placement named in an EHC plan, or a cease to maintain decision for an EHC plan. So when can you mediate? As parents and young people, your rights to try mediation are set out in Section 52 of the Children and Families Act 2014. A young person is defined as a child of 16 years or older, and the legal right would be theirs, but they're able to request your support with the process if needed. The Children and Families Act 2014 says you have a right to mediation where a decision is made which you could appeal to the SEND tribunal, or where an EHC plan is made, amended or replaced. Your right of appeal provides you with 2 months from the date on the decision letter detailing one of the following: a refusal to assess or reassess, a refusal to issue an EHC plan, the issue of a final plan following an EHC needs assessment or following an annual review, or a decision letter following a cease to maintain decision. When you have the right to mediation, there are lots of things you might need to consider when deciding whether or not to try it. Here are some of these factors to consider. Your right to mediation. Is your dispute something which can be mediated on? Does it fall into one of the 6 categories previously mentioned? Do you have a decision letter detailing the final decision? And are you within timescales to appeal the decision? Informal discussions with the local authority. You may have had a lot of discussions already with the local authority, so you may feel mediation would be of little use and you want to save time. If you have never had a proper discussion with the local authority about why it has reached its decision, then mediation may help. You might also think about mediating to give yourself more time to appeal. Bear in mind also that the person attending from the local authority in mediation likely has had no part in any decision making until this point. You are able to have these informal conversations with either your SEND case officer or a member of the Appeals and Resolutions team at BCP Council, as a form of early dispute resolution. Consider the current SEND Tribunal appeal hearing timelines. You may want to consider that as of January 2024, it can be a little under a year for an appeal to the SEND Tribunal to be heard, and this may affect your decision on mediation. Although asking for mediation will delay the point at which, if it's still required, an appeal is submitted, it will only delay it by a maximum of 30 days. This is because if the local authority cannot arrange it within the 30 days, the mediation advisor must give you a deemed mediation certificate within 3 working days of the local authority telling them this. This certificate allows you to submit an appeal, but you retain the right to mediation and can insist that this happens even if you have registered an appeal. Mediation has the potential to resolve all or some of the issues that are in dispute much more quickly. This means that it is possible to achieve some improvements to the EHC plan well in advance of the outcome of the appeal. Annual reviews. If mediation is arranged around the time of the annual review, your mediation session should still go ahead. This is because mediation is an opportunity for parties to try and find an agreement with the help of an independent mediator. This person will be experienced in helping people reach agreement and will have knowledge of SEND law. If an annual review is due at the same time you are mediating or appealing a decision, the annual review must also still happen and may provide you with a further opportunity to reach an agreement. You may also wish to consider requesting an early annual review if there is good reason to do so. In some situations, you are required to consider mediation before you can make an appeal in the SEND Tribunal. You are not required to consider mediation if the dispute is regarding only the name or type of setting named, or the fact no name or type is stated in Section I, but you can request mediation if you wish. It is sometimes worth considering when appealing the placement if amendments are required within the needs and provisions sections of the plan to ensure they reflect the child or young person's needs and support fully. If you wish to make a claim for disability discrimination, there is no right to mediation here. In all other appeals, you need to consider mediation first and obtain a mediation certificate. This means you can decide if you wish to mediate or not, but in either case, you will be required to inform the mediator of your decision. The details of the mediator is provided on the decision letter provided to you by the local authority. If you do not wish to mediate, you should make contact with the mediator within 2 months of the decision. Explain you have considered mediation, but wish to appeal straight to the tribunal requesting a certificate. You will then receive a mediation certificate within 3 working days, providing you with your right of appeal to the first-tier tribunal. You will need this certificate to send with your appeal paperwork, so keep hold of it. If you initially say you do not want mediation and receive your certificate, but then change your mind, you should call the mediation advisor back within the 2-month window and explain that you have changed your mind and would like to try mediation. If you do wish to mediate, firstly, make contact with the mediator within 2 months of the decision. Explain what the issues are you wish to mediate on. Also, advise if you wish to discuss the health and/or social care sections of the plan. Mediation will be arranged within 30 days by the mediators. Inform them of any supporters also attending the meeting before the mediation itself. Supporters could include a friend or a SENDiass officer. You may also wish to request another professional attends with you to provide evidence, such as a health professional or representative from the school. You should prepare the issues you wish to discuss along with any additional evidence you may have. It is advisable to share this information with the mediator and the local authority prior to the mediation date, so all parties are fully informed of the issues to be discussed, ensuring your meeting can be as productive as possible. Some things to remember. Everything discussed in the session is confidential. Nothing discussed or agreed in the meeting can be used at tribunal. It's okay to show emotion, but remember, it is a non-adversarial process. The local authority representative has very likely not made any decisions up to this point. You'll be provided with an opportunity to have uninterrupted time to speak. The local authority will be provided with the same, followed by an opportunity for discussion. You may wish to prepare a statement to read during the session. As well as the issues to be addressed, also consider painting a picture of your child or young person. The mediator and local authority representative likely know nothing about them other than what is written in documents. So by letting them know who they are as an individual helps to put them at the centre of conversation and decisions, as it is, of course, about them. If you have gained your child or young person's own views to contribute, if they choose not to be part of the meeting, then consider presenting these too. You may also be supported, for example, by a friend, SENDiass officer, or health or school representative. The mediation session will end with a mediation agreement. The mediator will produce a document detailing everything that has been agreed. It is important to ensure timescales are stated for the actions agreed, and the local authority and integrated care board must do what is agreed. There are legal deadlines by which some actions must be carried out following an agreement at mediation. These are set out in Regulations 42 and 44 of the Special Educational Needs and Disabilities Regulations 2014 and will always apply unless you agree different timescales. In cases where the local authority agree to carry out an EHC needs assessment, within 2 weeks, the local authority must tell you that it is starting the assessment. Then either let you know that the local authority has decided not to issue an EHC plan within 10 weeks, or send a finalised EHC plan within 14 weeks of the mediation agreement. If the local authority has agreed to issue an EHC plan, they must first issue the draft plan within 5 weeks and the finalised EHC plan within 11 weeks of the mediation agreement. If the local authority has agreed to change the name of a school in an EHC plan, the local authority must issue the amended EHC plan within 2 weeks of the mediation agreement. If they agree to make amendments to the plan, they must issue the amended EHC plan within 5 weeks of the mediation agreement. If anything else is agreed within mediation, such as agreeing to some temporary funding or professional input, they must do it within 2 weeks of the mediation agreement, unless agreed otherwise. If you require any further support with regards to preparing for mediation or through the mediation process, you can visit our website at SENDiass4BCP.org for further information and resources. You can also email us at help@SENDiass4BCP.org, And we also have an advice line available to you Monday to Friday, 9:30 till 12:30.